Wednesday, December 27th, 2023. This is in regards to the Los Angeles Department of Water and Power, case number 1263-80. I'll repeat that. This is in regards to Los Angeles Department of Water and Power, case 1263-80. Today is Wednesday, December 27th, and we are here for an interim variance request regarding rules 203, 2004, and 3002. And who is here on behalf of the petitioner?
My name is Nick Carno. Oh, right. Is that on now?
Yes.
Thank you. Nick Carno. I am the city attorney representing LADWP today, Los Angeles Department of Water and Power. And to my left, maybe we can go down the line.
Okay, when you do say your name, if you can spell it for the clerk, please, and give them your title.
Sure.
And how long you've been with the...
Last name is Carno, K-A-R-N-O. And like I said, I'm the city attorney representing Los Angeles Department of Water and Power. And I've been in this position for a year, so.
Ian Guthrie, manager of the Haynes Generating Station. I've been with LADWP for 21 years.
And can you spell your name, sir?
That's I-A-N as in Nancy, and last name is Guthrie, G-U-T-H-R-I-E.
I'm Catherine Rubin. I'm the Director of the Corporate Environmental Affairs. Catherine Rubin, Director of the Corporate Environmental Affairs Division with the LADWP, and I've been with the department for over 30 years. My name is spelled, my first name or my last name? Oh, my first name is spelled K-A-T-H-E-R-I-N-E, and my last name is R-U-B-I-N.
Okay, and will you be having witnesses today?
Yes.
Okay, and Mr. Tomasovic, will you be having witnesses today?
Yeah, good morning. And to introduce myself for the record, my name is Brian Tomasovic. I'm Assistant Chief Deputy Counsel representing the executive officer today. I'm joined by staff who I would introduce later if a witness were needed, but I'm not intending to calling a witness.
Thank you. Okay, all of those who are going to be presenting any testimony, if you can, please stand, raise your right hand and take the oath. Okay, do you, under penalty of perjury, do you swear that you will be telling the truth, the whole truth and nothing but the truth?
Yes, I do.
Okay, thank you. All right, with that, we do have an exhibit, which we are going to be marking A as an apple coming from the district, and that is the proposed draft interim variance conditions in regards to this case for LADWP and the Haynes Generating Station. All right, and we don't have any other exhibits that you're going to present?
Just exhibit 1 and exhibit 2 that should be part of the package.
Petition?
Yes.
Okay, so we will mark them as they are listed as 1 and 2. And Madam Clerk, I do not have a copy of that. Okay, oh, I'm looking at my petition, that's why. Yeah. Let me make sure. Well, I have everything. Here we go. I have a second copy here. Yeah, I got it. Here, these. Right, and then 2. Yeah, got it. All right, as mentioned, we will go ahead and be marking exhibit 1 as marked. Those are the photographs. And then exhibit 2 are the pages from the Haynes Generating Station, the Title V permit. And I believe that is all of your exhibits, correct?
Yes.
All right. Thank you, Madam Clerk. All right, so with that, we can go ahead and start with our opening remarks. And if you want to go ahead and start, sir.
Yes, thank you. And good morning, everybody. And thank you for convening on the last week of the year. I know this is not ideal, but this was almost an emergency variance, but we were able to file and submit everything for an interim in time. And just to give a pretty brief, I guess, background, I think this board is a little bit aware of us coming before here literally last Tuesday, or not yesterday, but the day before on the 19th, where we had an item that was on consent before this board. It was that night that Haynes Generating Station Unit 2 suffered a catastrophic failure, and realized that we were not going to be able to complete the testing requirements. The deadline was for the new year, December 31st, in which case we were faced with needing to come in for a variance in a very short order. We immediately put together the petition, filed last Friday, and we're here before you today. We're seeking 90 days, if possible, or at least enough time for us to file our regular variance petition, because this is similar to other failures that we've had. It's going to take a long time to repair this unit, and we're going to be out of compliance for at least a year. So we're seeking to have a variance period up to December 31st of 2024. It's pretty simple and straightforward case, so I don't know if I need to belabor too much, but I would like to just emphasize that we realized that we had to do this in a very short amount of time, and that being on a Wednesday morning the last week was probably not ideal for everybody. So we just are really grateful that you're willing to sit down and listen to us and consider our variance.
One thing I wanted to interject here that I didn't mention at the beginning, based on the fact that this is an interim request for a variance, we do bifurcate it. And the first part is that you can have to establish a good cause. And if that can be established, then we will go on to the second part, of which is the 6 findings.
And in looking through that, I had a question for the board in terms of how to go about that, simply because much of the testimony that we would elicit for good cause also is many times some of the same elements that we would have to show for the 6 findings under 42-352. So what we were thinking is that we would just provide our testimony, and then I don't know how the board, do we want to provide the testimony a second time? Or?
What normally happens is that the petitioner does establish for us and gives us all of the reasons why good cause should be found. And then we deliberate on that, also with, obviously the input from the district. But you can go ahead and you can make those notes, and then I should say make those comments in regards to good cause, so that we can go ahead and have the idea of what is occurring. And then what we normally do is we enter it into evidence, and you can mention the fact that it's been that information has been entered into evidence if you are able to go ahead and present for good cause, or I'm sorry, for the 6 findings on the second part.
Okay, thank you. Well, let me first go through some of the elements that was presented to me as to how to establish good cause. And I'm specifically referring to Appendix 1 in the Rules and Regulations of South Coast Air Quality Management District that was provided to me, and also the questionnaire that has been provided to me by the clerk.
I just interject, because he's still on opening statement. Should we have the district, is he going to sound, he might go into some detail, but it's just opening. It shouldn't be that detailed. Let the
Yes.
district respond first.
Just an overview for your opening statements.
Yes. that the first that they were petitioner, and that is the LADWP, was in violation of specifically permit condition D28.3 and Rule 203B and Rule 2004 F1. And that the circumstances leading to the violation cannot reasonably been avoided by the petitioner, that the petitioner exercised diligence in petitioning for the interim variance and scheduling the interim variance hearing, and that the denial of the interim variance would result in an unreasonable and unavoidable adverse impact to the petitioner. So we can, if it's okay with the board, start our testimony now.
No, we're going to let the district go ahead and give their opening statements, and then we will come back to you.
Okay, thank you.
Mr. Tomasovic?
Members of the board, good morning again. In regard to good cause, the district does not anticipate that it would have any reason to dispute the timeline given in the petition or the evidence attached to it. We don't anticipate having any significant questions regarding good cause, including the element of diligence in petitioning. And in terms of petitioner's counsel mentioned that this may be a straightforward case, and we'd agree with that. A related valid observation is that there are no excess emissions. That concludes my opening.
Thank you.
Can I ask a question?
Yes.
Petitioner raised that something happened on the 19th after another hearing involving this facility, but what happened at the hearing on the 19th is not related to this event, right? It's completely different.
Correct. On the 19th, our matter was on consent calendar for this board, and it was for the Scattergood generating station. And that involved a different unit and different issues. This is for a completely different generating station, the Haynes generating station, located in a different location with a completely different unit and has different issues. But
Okay,
it was,
I just want to make
yeah.
sure, since I did not attend that hearing, I didn't have to read the results of that to be prepared today. Thank you. Please continue.
Okay, can I begin the questions to the witness?
Yes, go ahead.
Mr. Guthrie, you helped file the petition for this interim variance, correct?
Yes.
And that is primarily because we realized that the Department of Water and Power would be in violation of particular rules and regulations from the district. Is that correct?
That is correct.
And what rules and regulations would are your generating station in particular that you manage be in violation of?
It would be specifically our permit condition D28.3, which requires an annual ammonia source test. The test to be conducted, the condition, sorry, states the test shall be conducted at least annually. If an annual test has failed, the facility shall conduct source tests quarterly. 4 consecutive quarterly source tests must demonstrate compliance with the ammonia emissions limits prior to resuming annual source tests. That also would be a problem with Rule 203B, which states the equipment shall not be operated contrary to the conditions specified in the permit to operate, and Rule 2004 F1, which states the facility permit holder shall at all times comply with all rules and permit conditions applicable to the facility as specified in the facility permit.
Okay, how is it that the generating station that you manage is or will soon be in violation of those rules or conditions?
The way the permit condition reads, we're required to perform an ammonia source test annually, and we have not performed an ammonia source test on that particular generating unit this calendar year. So in light of the condition of the generating unit, we will not be able to complete that ammonia source test during this calendar year.
And could the plant that you manage have avoided the circumstances that made this variance necessary?
No.
And why not?
The damage or the issue that occurred last week on the 19th of December is completely unanticipated and unexpected, and is likely going to require a significant amount of work to be able to repair.
And could the Haynes Generating Station have anticipated those circumstances in time so that we could have had a publicly noticed hearing?
No.
And why is that?
The damage, the situation where we had our vibration event and trip of our generating unit occurred at roughly 7:10 p.m. on Tuesday night, December 19th. It was a completely unexpected event. I'm not sure if maybe you could repeat the question, sorry.
Just if we could have anticipated, or if your, generating station could have anticipated the circumstances that led to the failure.
Yes, no, we did not and would not have been able to anticipate the situation that occurred. At this point, we don't understand exactly what occurred, as it takes a lot of work to expose the components. So there's no way we would have been able to know ahead of time, before operating our unit to have an event occur.
You stated that the failure occurred at around 7 p.m. on Tuesday, the 19th?
That's correct.
And was that when you first knew that a variance would likely be needed?
Very likely, yeah, within kind of processing this phenomena, the kind of looking at the data from the operation of the unit at that point in time. I think that certainly by the early morning of December 20th, I think we knew we needed to file a request for a variance in that permit condition, because there's no way we were going to be able to operate the unit before the end of the year.
And when was the petition filed? It's before the board right now?
Friday, the 22nd of December.
Okay. And so within that 2 days, can you discuss what went into putting that filing together?
Yeah, I think going through the normal variance application process, providing the information regarding the event that occurred, understanding what particular rules or permit conditions might be that we would not be in compliance with as a result of the damage or event that occurred with our generating unit, to demonstrate that it was appropriate to request a variance for that permit condition.
Okay. And is there any harm to the public or the environment if we wait for a publicly noticed hearing? Specifically, well, let me back up. Is Unit 2 operable right now?
No.
Okay. And are there any emissions from it?
No.
But will we be in violation come December 31st of this year? For
No,
reporting the testing?
No, come January 1st. Sorry.
Oh, January 1st. Okay. So come January 1st is when, of 2024 is when we'll be in violation?
Yes.
Okay. And so is there what, I guess, impacts would there be to Department of Water and Power if we were to wait after January 1st in order to have the hearing? Would we incur fines?
It's my belief that we would be out of compliance with our permit condition, which would subject us to penalties associated with not complying with the permit.
Okay. Okay, is that satisfy the board in terms of the elements for a good cause, or would the board like more inquiry?
What'll happen now is that the district has the right to ask questions, and then the board will ask questions.
Okay.
Mr. Tomasovic?
Hey, good morning. I just have one or two general questions. The petition states the unit was built back in 1963. Are there plans to replace this unit anytime in the future?
Yes, there are. I believe there's a tremendous amount of uncertainty with what those plans are currently, but there is currently a requirement for us to curtail the use of ocean cooling by December 31st of 2029. And so we have plans in place to replace the generating capacity associated with units 1 and 2 at Haynes prior to that time. Although at this point in time, we don't have a clear picture of what that looks like.
Relatedly is the, at this point, great age of the unit at all related to the breakdowns and problems it's having, or are these par for the course?
The age plays a factor. What we generally find is that the older equipment, such as this vintage of generating unit, is very robust. The way they were designed and built and constructed in the early 60s was allowed for them to operate much further beyond their design life. Although the unfortunate portion is that it is difficult with resourcing with units that don't operate as often as other generating units that are more efficient to maintain or address the upkeep with those units. And as they age more, the upkeep or the maintenance, I would say, is greater. So if that answers your question, the age could play a role in it.
That does, and I believe some parts of your exhibits indicate you had to do custom parts for such an old turbine.
That is correct.
I pass the witness. Thank you.
Thank you. Okay, in reference to the unit, when was the last maintenance on the unit?
We have maintenance on our generating units scheduled annually to facilitate inspections that are required for renewing our state operating permits for the boilers. We'll do inspections of all of the associated equipment and make repairs that are corrective maintenance repairs or preventative maintenance repairs during that time. The maintenance for this particular unit really kind of occurred between the time when the initial or previous failure had occurred on the generating unit in roughly September of 2022 throughout the period of the fall of 2022 and kind of ending probably roughly in around June or so of 2023.
Okay, and you stated that this is not a regular load unit. This comes on for additional power when there's more demand. So it's like a peaker plant.
In a sense, yes. It would not be designed to be a peaking plant because it's a 1960s vintage steam generating unit. They were designed to be a base load, but the way they're operated is that you would only really call to use those units when there is either an issue with enough capacity at our existing facility, or if you need to have that much more capacity available to meet the demand within the system, which would be more of that quote unquote peak time of like the summer.
Okay. Any other questions, board members? Mr. Pearman?
First, IPLP stands for what? Just intermediate low pressure.
Intermediate pressure, low pressure.
So it's a combination, in other words, turbine?
I'm sorry, can you repeat that again?
Combination of intermediate and low pressure?
Yes, this particular turbine has a high pressure turbine rotor coupled to an intermediate pressure turbine rotor coupled to a double low pressure. It has not to get too technical, but it has one portion of the low pressure. It has two low pressure turbine rotors that are bolted to each other. They face kind of mirror image of each other. And each one of those has an intermediate pressure portion of it. So there's a discrete intermediate pressure turbine rotor, and then there's an IPLP rotor, and then another IPLP rotor.
So back in September, when we had the failure with IPLP2, I love the phraseology, its blades were liberated. Sounds so positive and optimistic. Did you do anything at that time to check IPLP1 to see if they were in the process of being liberated as well?
The only thing we were able to do due to our resource restrictions or limitations to be able to access the turbine blades that had failed on the IPLP2, for example, required a significant disassembly of all of the cases associated with that particular turbine rotor, or that portion of the steam turbine. So the most we could do at the time was to do a visual inspection of the very last stage blades. That'll be the 5th stage LP turbine blades. Where we saw the damage in the IP LP2 rotor was in the 4th stage blades, which really are inaccessible unless you actually completely disassemble the machine.
So you really, at this point, you don't know which blades in IPLP1 actually failed.
Yeah, we actually don't know. We haven't, because there's a period of cool down required to be able to shut down first you have to shut down the steam turbine, which happened already. Then you have to cool it down and then secure all the cooling systems to go in from underneath and sort of internally inside the steam condenser portion of the steam turbine to then attempt to make your way up and inspect the back end of the machine and then see if you can observe any damage. We haven't been able to do that yet because it's just getting cool enough at this point for us to open up and try to have people go inside and perform that visual inspection. So we don't actually know at this point if it was a failure of the components that had been replaced, that were remanufactured blades from the IPLP2 initial event that occurred, or if it's the same type of components in the other IPLP rotors, such as IPLP1. Our initial look at the vibrations on the turbine bearings would be a little bit more suggestive potentially of it being the IPLP1, especially in light of the condition that had been observed previously, but we don't know yet. It's just speculation at this point.
And when you said resource limitations prevented you from the total disassembly in September to look at IPLP1, is there some cost dollar figure you can give us to what that would have cost you to do?
If I was just going to throw kind of a maybe an educated guess, I would say the disassembly portion would be potentially about $500,000 to $1 million or so to expose that. Our bigger challenge, obviously cost is a very important consideration, but the bigger challenge is we didn't even have the personnel to be able to do the work. We were stretched thin to even do the work on the portion that we knew was for sure damaged. And we were unsuccessful in really getting any outside support from, in this particular case, General Electric now owns the IP associated with the Brown Bavarian machines. And we'd kind of pressed them to try to get some at least proposals for supporting labor to do more inspection. And I think they were stretched thin with other catch up of work throughout the whole system, or the industry.
No further questions.
Okay, in reference to that, so only your own personnel has taken a look at the unit and the damage to the unit so far. You haven't had anybody else out there, like a contractor and or GE, is that correct?
What for the event that occurred on December 19th, or
Right.
No, yeah, nobody has looked at anything. We've only looked at the initial data.
Okay, thank you. Mr. Balagopalan?
Yes, good morning, Mr. Guthrie. So the repairs were done at your site. It was not shipped to Houston or GE site or anything like that.
The equipment?
Yeah, for when it went down September last year, when you took it down.
We did have to remove the IPLP2 rotor, uncouple it from the machine and remove it to have the 4th stage blades removed and replaced, as well as the 5th stage blades that had been damaged, collateral damage. That work was done at a facility, Bender's CCP, which is a local machine repair shop, heavy equipment repair shop. I believe in Vernon or in that area adjacent to downtown Los Angeles. They were contracted through GE or subcontracted through GE to do that work under the direction of GE, as they had to kind of remanufacture the turbine blades that were being installed on that particular machine. Otherwise, all the work is done on site.
Okay. The the petition is for says for boiler. Now the boiler is not operating because the turbine is offline, correct?
That is correct.
And so really, and there's a source test on the, you cannot do because the source test is for the SCR unit that's venting the boiler.
That is correct. And the permit condition requires us to operate at 60% load or greater, which requires the unit to be synchronized to the grid and operating at a certain capacity.
So, and I'm looking at the proposed condition, it says repair of unit 2, the unit, and in parentheses was device D4, which is a boiler and SCR. You don't have to do any repairs to the boiler at the SCR, it's the repair to the gas turbine really. And the blades, you have to open up, check and see what's wrong, what got liberated and so forth,
Yes.
and do the repairs.
Yes.
Okay.
That is correct.
So okay, I just want to clarify that, and I think the wording might need to be clarified. Why do you anticipate, I mean, it looks like the unit was down in September, you did the repairs and brought it back and everything, and ran through the testing, and then because you have a failure. But why do you anticipate taking another year to do the other additional repair if necessary?
We found that unfortunately, because it's the vintage of the machine, it required roughly 4 months lead time to manufacture the turbine blades. And right now we're having a lot of hard, I mean, I guess maybe it's been very challenging for the manufacturers or the vendors that can manufacture these types of equipment to find raw materials. So that's impacting lead times for them. So we're really just kind of throwing a guesstimate out there based on our experience with the duration of repairs associated with this past failure that had occurred. So I think, again, the challenge is with the limited resources we have, it takes a long duration to do the work to expose the equipment. In addition to that, we have the manufacturing lead time, which at this point, because this happened so recently and so close to the holidays, we haven't received any kind of feedback yet from GE as far as what a lead time might be for manufacturing those particular parts. If it turns out it's the particular parts, need to be, again, manufactured, and we also don't know the extent of damage. So, we're not sure if it's going to be additional lead time or not. So I think it's really looking at this past experience as maybe a benchmark.
Okay, so it's abundance of caution. You're asking for a year.
That is correct.
All right, thank you. I have no further questions.
Dr. Abraham, did you have any questions?
Yeah, no further questions.
Thank you. Okay. All right, you can go on to your second witness.
Sorry, that's our only witness.
Okay, so that's it for, okay. All right, so in reference to then good cause, you can go ahead and make your closing statement. And if you can please refer to the elements of good cause.
Yes. Petitioner believes that good cause exists to justify the holding of this interim variance petition in the absence of notice to the public, because I believe the evidence has demonstrated that we will be in violation of our permit and of Rule 203B and Rule 2004F1. Believe the evidence has demonstrated that the circumstances leading to the violation could not reasonably been avoided, and that this was a part that broke that we were unable to ascertain or even inspect long before. We believe that the evidence shows that the petitioner exercised diligence in petitioning for the interim or variance, in that sense that we were able to submit this within 2 days after the event to get this before this board as soon as possible. And that we believe that the denial of the interim variance would result in an unreasonable and unavoidable adverse impact in incurring fines for circumstances that are beyond our control. And just to note that there is no danger to the public simply because the unit is inoperable and there are no emissions at this point. Thank you.
Thank you, Mr. Tomasovic.
The district does not oppose the hearing board making a determination that there's good cause.
Thank you. Okay, board members, if we want to go ahead and take a look at not only the conditions that were presented to us in Exhibit A, but also the testimony that we have just received, which will be entered into evidence. I, for one, don't have a problem finding good cause because of the time frame. It was just 2 days, and also because of the fact that you are required to have that cooling down period before you can actually get in there and diagnose what the problem is, and therefore you don't really have a opportunity to know which type of vendor to call in. And as you said before, the lead time in reference to the manufacturer, that will be impacted as well. So for myself, I can find good cause. Board members, Mr. Balagopalan?
Yeah, I agree. I too can find good cause. There will be in violation of the requirement D 28.3 to do the source test. They can't do the source test because the unit is not operating. So and so the ammonia slip test cannot be done by December 31st this year. The circumstances could not have been could not have been avoided or anticipated by the petitioner. I think we heard testimony in the petition that the unit was down 2022 in September, and they sent it and went through some extensive repair and came back, and then when they normally when you put it back together, then they did the vibration analysis and they found that there were some issues also, and they had to further shut it down. So I think they didn't anticipate the IP1 having issues potentially. That's where they might be. And then once they knew there was a problem, they were very diligent, I think, as we saw from the timeline in filing for this interim variance. So within a couple of days, and the denial of the variance, there will not be any increase in emission or any adverse impact because they're not operating, but unreasonable adverse impact of the petitioner if they will continue to get a notice of violation and for not doing the test in a timely manner. So for all these reasons, I can find the for good cause also findings to move forward to the interim variance.
Okay, Mr. Pearman?
I concur. Nothing to add.
Thank you. And Dr. Abraham?
Yeah, I agree with everything that Mr. Balagopalan mentioned. And then for the denial would, I believe, also adversely impact the people of the city of Los Angeles. I think this is found here. Thank you.
Thank you. Okay. All right. We can go ahead and proceed then to, did you want to make any motion, Mr. Balagopalan?
Yeah, I'll go ahead and make the motion for the finding a good cause. So in the matter of LADWP Haynes Facility, case number 1263-80, I move that we find good cause to proceed to a hearing for an interim variance in absence of notice to the public based on our discussion and ability to make the findings for good cause.
Thank you.
I would second that.
Thank you. Any discussion on the motion? Okay, with that, let's go ahead and take the vote. Dr. Abraham?
Aye.
Mr. Pearman?
Aye.
Mr. Balagopalan?
Yes.
And myself, I also vote aye. So we can go ahead now and go to the 6 findings. Excuse me, I'm also starting to lose my voice. So if you can, we have mentioned before that this is for an interim request for a variance in regards to this case 1263-80. We can go into the second part of this hearing for the 6 findings. And we will go ahead, as I mentioned before, we have entered all of the testimony and the exhibit into evidence. And if you want to go ahead and give us a overview of how you feel that the 6 findings can be met.
Thank you. Yes, and considering all the testimony that we've already heard, we've discussed as finding number 1 that the LADWP will be in violation of our permit rules and Rule 203B and Rule 2004F1, which is required under finding number 1. Under finding number 2, we believe the evidence will establish that, due to conditions beyond reasonable control of our Haynes Generating Station operators and Los Angeles Department of Water and Power, that requiring compliance would result in an arbitrary and unreasonable taking of property, considering the fines being the property, and that in making these findings where we are a public agency, we'd ask that requiring immediate compliance would impose an unreasonable burden upon our essential services that we provide. And that's for finding number 2. For finding number 3, we believe the evidence would show that closing or the taking would be without any corresponding benefit in reducing air contaminants because the unit is inoperable and therefore not emitting. So in that regard, finding number 3 can easily be made. Finding number 4, that the applicant for the variance, the LADWP, would be as given consideration to curtailing operations of the source in lieu of obtaining a variance. Again, the source is offline, so it has its operations have been curtailed if that have essentially taken offline. So that element is satisfied. For the 5th finding, during the variance period that the DWP is seeking, we will demonstrate through testimony that we will reduce any excess emissions to the maximum extent feasible. And obviously, while the unit is inoperable, there will be no emissions. However, if and when we do get it running, we will demonstrate the pains it will take to reduce emissions to the maximum extent feasible. And under finding 6, we will show through our evidence that we will monitor and quantify emission levels from Unit 2 when it is up online and report those emission levels to the district pursuant to rules and regulations that are required.
Mr. Tomasovic?
Thank you. The proposed conditions in Condition A were shared with the petitioner in advance, subject to the hearing board's adoption of those proposed conditions. We would not oppose the granting of a variance. There is a question here in terms of health and safety code. It was brought up being an essential public service. And in terms of that phrase does, I think, apply to them. Does it apply statutorily to them under Health and Safety Code, Section 42352? I'm not sure of a definitive answer to that because it does say for purposes of this paragraph, essential public service means a prison, detention facility, police or firefighting facility, school, healthcare facility, landfill gas or processing facility, sewage treatment works, or water delivery operation if owned and operated by a public agency. There may well be past cases where we've said power plants by LDWP are fine for that, but I also can't speak definitively to whether we've stated a position on that. I don't think that's an obstacle or a hindrance because in terms of the conventional showing that's needed by a petitioner for a variance may not be a high hurdle for them here. In terms of the question about taking another year to conduct the repairs, I think there was good evidence that that's an uncertain issue. In terms of needing a future noticed hearing, it's possible that there could be a refined picture. So the district has an open mind about coming back to the regular hearing with maybe adjusted conditions. But in general, what we have in Exhibit A tracks with what has been presented in similar cases. We do have, from our perspective, certain safeguards in place. When the repairs are completed, the clock starts to try and get in there and comply by doing the ammonia testing that's needed. And additionally, a little adjustment in Condition 2 clarifies that when they do that test, it counts for calendar year 2023. And so we would hope that they are separately doing another test that would count for 2024 to get back on track. And if there are any questions about Exhibit A, I'm happy to take those, but that would generally constitute the same statements I would make for any kind of closing.
Okay, thank you. All right, sir, do you have any other comments that your witness wants to make at this point to add to what we have been discussing and in reference to the 6 findings?
No, I believe though that we hadn't mentioned, and I want to mention now that we were given a set of the proposed conditions, and DWP was completely okay with all of them and have no objection to having any of those conditions applied.
Okay, and that would include the fact that, as Mr. Tomasovic mentioned, that the testing would be to satisfy 2023 and you're prepared to do 2024,
Yes.
right? Okay, any other questions from board members? Well, he just made a statement. Okay. Oh, the only question that I have, and it's kind of more of a overall suggestion, you had mentioned that at this time, you're not sure based on the age, whether it's going to be some type of a replacement and or if you're just going to repair what you have. Based on the costs that are obvious that this is going to take a lot of money to do this, I'm wondering if it's throwing good money after bad and not looking at something that's more efficient, something that is going to have new technology that will have even lower emissions possibly. I in particular am interested in that and would like to look at that. And I do like also the mention that Mr. Tomasovic made of having a hearing in between now and the end of 2024 to see where we're at. Definitely. And I would propose that we add a condition number 7 that we would come possibly in May, June.
No, it's already calendared for February 8th.
February? That's the regular one.
Yeah.
I would still like to have one beyond that. At that time, okay. All right. So any other questions or comments, board members? Mr. Balagopalan?
I do have for Mr. Guthrie. I know you mentioned Rule 203B and 2004 F1. In your petition, it also includes, with rightfully 3002C1, and I'm assuming you want to include that too.
That is correct.
Okay, all right.
I'm sorry about that.
No, that's okay.
My mistake, actually.
It's in the petition, so so just for, because you're a Title V facility, that 3002 applies also. Now, looking at Exhibit A, I just want to clarify, and let's look at condition number 1. It says, and I just wanted to note, it says shall complete the repair of Unit 2, but in parentheses is D4 and C75. Okay, let me know when you see the conditions.
You're talking about Exhibit 2?
Exhibit A, the proposed condition, the draft interim variance condition.
Sorry.
Yes, ready.
So it says repair of Unit 2, but in parentheses is device D4 and C75. Device D4 is the boiler and C75 is SCR, right? So it's not those units have been repaired. It's really the
steam turbine.
the steam turbine. So do
Generator.
you know, and that's under umbrella of Unit 2.
Correct.
So do you know what device that is, or?
It's not a device
unit?
explicitly referred to in our permit. I believe the description is in the equipment description portion of the permit, but it's not a device that has the emission requirements explicitly. As you stated it, those are the boiler and the SCR.
So it's in the broad, because the permit showed only the boiler and the SCR. So it is in
Yes.
the Unit 2, basically, description.
Yes, and I can confirm that
Okay.
for you. And I was mistaken. It does not appear that it's in the equipment description either. It just references at the very bottom of the equipment description, generator, 230 megawatt.
Okay, so there's no reference to the gas turbine at all in the description?
It's not explicitly described. It literally just says generator, comma, 230 MW. So I think it's implied that that equipment is kind of related to it, but it doesn't explicitly say that.
And were you seeing that in the exhibit you gave us, or
That would be in exhibit
one?
exhibit 2
Oh, 2,
from our
yeah.
permit, and that is on page 2 of the permit under section D, process 1.
Right, but see that only shows the boiler, and that's where it says the reference to 30. I was wondering if there's any prior page prior to that that has the gas turbine.
Not that I'm aware of. Yeah, in this case, it's not a gas turbine, it's a steam turbine. So it doesn't by itself produce any emissions, unlike our other units, which are gas turbines.
Okay, so, okay.
That might be why there's the difference.
Okay. And the reason because it says in parentheses, you put device D4.
Correct.
But device D4 is not the repair,
That is correct.
Correct. So you want to give something, a better description, what the repair of the gas turbine, the steam gas turbine is.
Yeah, so we can, because the compliance is with the device D4 and C75, obviously, I would assume we have to still reference those in the conditions.
Right.
Although, yes, I would agree that clarifying that it's the repair of the unit number 2 steam turbine associated with device D4 and C75.
Okay. All right, thank you. And I'll check the district if they have any objections to that wording.
That wording sounds appropriate.
Okay. Now let me go to condition number 5.
Yes.
And you familiar, if you had a chance to look at that condition?
Yes.
Okay. I know LA's DWS category, this is same condition from the previous permitted, variance they've issued. Now, which of the two options, are you familiar with what happened, the last sentence said, in lieu of the above mentioned requirement, the petitioner may choose to comply with the requirement of 212C2D and 212C2E as amended on November 3rd, 2022. Are you familiar with what occurred last in November when the governing board amended that rule?
No, I am not.
No. Okay. All right. So at this point, then the conditions say you will operate the SEMS, even though you have an other option because the rule got amended, so you don't have to do that. It's something that you will look at then because
yes,
it's in the condition. Okay, so you may choose to exercise one or the other if it's appropriate.
Yes, we will review permit condition number 5, and I know we can commit to maintaining our SEMS,
right?
And that would be our normal operation, but we will look at and review the amended rule to see what makes more sense for us, obviously.
And then you will notify the district appropriately which course of action you're taking.
Yes.
And you'll come back during the regular variance and let us know
Yes.
what you did. Okay.
Yes.
Then I have no further questions. Thank you.
Mr. Pearman, did you have any other questions or comments? Dr. Abraham?
No.
Okay, so we can go ahead and you can make a final statement, sir, in regards to wrapping up your closing statement.
Yes, again, thank you for hearing us. I know this is in short order. We just want to impress upon this board that we acted with immediacy and take this very seriously. We are doing our level best to rectify the situation, and will hopefully show improvement, or at least have a lot more information for you during the regular variance hearing if you're able to grant us this interim variance hearing during this period. Thank you.
Thank you. Mr. Tomasovic?
Just a quick remark that the suggested wording change about steam turbine associated with device number D4 and C75, as we talked about for condition 1, might also apply to condition 5. The district wouldn't have any objection to that. But in terms of there's nothing to add to our prior comments. Thanks.
Thank you. And Madam Clerk, are there any members of the public who have a hand raised that they want to make a comment?
There are no members of the public with hands raised at this time, Madam Chair.
Thank you. Okay, with that, board members, did we want to go ahead and go over the deliberation based on the fact that we have entered into evidence and passed that on from good cause to making the 6 findings? Mr. Balagopalan?
Yes, thank you, Madam Chair. I do believe I can make the finding for the 6 findings for granting the interim variance. The petitioner will be in violation of the permit condition to do the ammonia testing by the end of this year, which they're not able to because the turbine is down. Requiring it, non-compliance is beyond their reasonable control, as we heard. It was a failure of what they thought was going to work when they repaired it, but they shut down because once they found out that it was there were some issues with the repaired unit. So the non-compliance is beyond their reasonable control at this time. Closing or taking would be with their corresponding benefit. There's no emission, so the harm to the petitioner outweighs the benefit to air quality. If the emission associated with variance are eliminated, so really it's not much of an issue because they're not in operation. The petitioners given consideration of curtailing operation, they are shut down, so that's take care, satisfy that. During the period, the variance, in fact, petition will reduce excess emission. There's no excess emission during this period, so that's not an issue. And then the last one is they will monitor, I think, or quantify the emission. So they're nothing to quantify, but condition number 5 addresses that issue about monitoring to show there's no emissions during the period, or they may choose, hopefully, like I said, the board specifically amended that rule so you don't have to continually run the SAMs during the whole year while the unit is down, so you can do the alternate, which is there's certain things you have to do up front, and then you don't have to continue to run the SAMs to just record nothing, basically. So for all that reasons, I think the 6 findings has been met, in my opinion.
Thank you. Any comment, Mr. Pearman?
I agree. They've satisfied it, so.
Thank you.
With the motion.
Okay, well, we haven't made a motion quite yet. Dr. Abraham?
Yeah, no, I agree with all the 6 findings, and we've already found good cause, so I'm happy to proceed as well with once the motion is made.
Okay, thank you very much. I'll go ahead then and start with the fact I also agree that you have made the 6 findings. I commend you for coming in as quickly, notifying us as quickly as you did. Sometimes we don't get that all the time. And the fact that you are on the road to fixing this and or looking at replacement, I appreciate that. So in reference to the case of LA Department of Water and Power, case number 1263-80, I move that we grant the motion for the interim variance located at 6801 East 2nd Street in the city of Long Beach, 90803. It will be inclusive of the proposed conditions with the amendments that were made to number 1 and also number 5, and recognizing that in number 2, that there will also be a need for them to satisfy the conditions for 2024. Let's see, this would be inclusive of boiler unit 2 and SCR unit 2. This is in reference to rules permit condition D 28-3, 203B, 2004 F1, and 3002 C1. And we, as mentioned before, there are no emissions in regards to this event. So therefore, I again am making the motion that we grant the interim variance.
Just add, I think, commencing January 1, 2024.
Yes. Thank you.
And continue for 90 days until the regular variance is held, whichever comes sooner.
Correct. Thank you for that amendment. Okay. Any
Second.
Thank you, Dr. Abraham. Any discussion on the motion? Okay, with that, we can go ahead and take the vote. Dr. Abraham,
Aye.
Mr. Pearman,
Aye.
Mr. Balagopalan.
Yes.
And I also vote aye, and thank you very much for bringing in the information that we needed to make this decision. We appreciate that very much, especially during the holiday week. I know it was short and sweet, but it had to be done, especially based on the fact that the end of the year is so close. So I appreciate you coming in because not everybody did. So, and also thank you to the AQMD staff and Mr. Tomasovic, which I guess we will not be seeing in the near future. So congratulations on your promotion and good luck with that. So with that, unless there's any other discussion on this.
No, I was just going to add, they did come before us last year on the 29th for the same
Really?
case plan to Unit 15. So
Yeah.
it seemed to be a trend, but
But we won't hold that against you.
Thank you.
Okay, so with that, the matter is closed and we, unless there's anything else, are adjourned. Thank you very much.
Thank you.